Suppose your lordship had an MLA who resigned to fight a new election and the speaker, there may be bizarre cases, I don't know, speaker said, no, I disqualify you. How long will it take a court to give a stay of that order, Malus? But here, Malus, none of these 4 or 5 possibilities is allowed to be tried because you adopt a 3-step procedure to annihilate the 10th schedule, which brings us to the harmonization principle. I'm not going to cite law, Malus, about harmonization from ordinary petty contracts to constitutional law. Your lordship's first principle is harmonization from statutory, delegated legislation up to the constitution. But I want to make the different point here that why did the 10th schedule come? We'll read Mr. Ashok Sen's speech in when he piloted this 85 thing. The whole purpose is that you have come through a party seat, you go and face the electorate again, whether with that party, independent or a third party. That's the whole long and short of this, Malus. Have your lordship ever heard this happening except in some very rare cases in England or other democracies? There's no concept, I've come on a party, I'll either resign or I'll just leave that and fight again from another party. That was the whole purpose of this. But what you are telling the court is that no, I will affirmatively not resign. I will not go to the EC. Why? Because I'm scared that somebody will disqualify me. But then what was Mr. Ashok Sen enacting in 1985, Malus? He's enacting a power of disqualification for changing a party. What is the purpose of 2/3 of parliament saying so if you can simply...
What is the harmonization principle that you're referring to?
Harmonization is this 4-fold, Malus, 5 originally with the faction, otherwise 4, are the flexibility, play in the joints, affirmative permissibility part of the 10th schedule. And the 2(1)A, 2(1)B is the negative prohibitory part. You can do all these 4 without doing the negative part. For the negative, you don't have to violate the negative part for any of these 4. I will say even if you go to the election commission, you don't have to violate a whip. You don't have to voluntarily give up your party. You say, I'm on principle, please decide this.
So in other words, you are saying other than those 5 instances,
4 now.
Everything else falls within the net of 10 schedule.
And one more thing I am saying. That 10th schedule, absolutely correct. And the 10th schedule has both parts. It has those 4, it has the negative. It creates a whole code by itself. Harmonization means that your lordship will adopt my submission and interpretation because it harmonizes the negative and the positive. Now for 30 seconds, see if your lordship does not adopt the harmonization principle. The only thing a lordship will have to validate is the 3-step procedure. There's nothing else, Malus. It's staring a lordship in the face. The 3-step procedure, I want to ask myself, Malus, in which case will the 10th schedule bite? Let's, Malus, be very blunt. What your lordship will do is your lordship's domain. But today, your lordship's other option, other than my option, which I am submitting most humbly and respectfully, is adopt the 3-step procedure or validate it or recognize it. Malus, then how will 10th schedule apply? It cannot. And then, Malus, your lordships would be actually adopting an interpretation which reduces the 10th schedule to vanishing point. Actually vanishes, not vanishing point, it vanishes. Every case of defection, I will say, I will not resign. I won't go to the EC. I won't merge. Merger is given to you by the para 4 of the 10th schedule. I will not do it. But as your lordships was told, I am the party, I am the overwhelming majority, I am the main person, I am it. Therefore, to hell with the 10th schedule. So on principles of interpretation and much more so of constitutional interpretation than even statutory. This is a much better way to look at it than the contrary view. Because your lordship gives meaning to both sides. And your lordship does not adopt something. What is this other adoption which is propounded to your lordships? On the high moral principle of democracy, dissent, free speech. Each of my 4 options gives you that option. So what the 10th schedule does is, it says, I am giving you a free speech option. I am giving you a democracy option, but within my own terms. I am not giving you a Jungle Raj free speech and democracy option. Otherwise, why would I enact a 10th schedule?
See, but merger, Dr. Singhvi, was not an option open to them because they were not claiming to merge their party with either the BJP or any other party.
With respect, I'm sorry to interrupt. Why not?
So, merger was not an option.
No, it was an option. No. They did not choose to exercise it.
You're right.
That's correct.
It's an option.
They chose not to exercise an option.
In the abstract, but they were not following the merger route at all because it's not their case that, look, this part of the Sena
that's exactly my point
with another party. That is not
That's
clear.
Exactly my point with greatest humility.
Then the only point is that in a situation like this, where they say that we have lost faith with the leader of the party,
yes,
then the only option according to you is that you resign and recontest.
No. I will stick to my 4 options.
That's
I'll say all the 4 options are
No. No.
What do they do then?
No. Whereas resign is one.
Right.
These 9 people will merge with another political party. Why not? But the fact that I don't exercise an option
That is not an option, because merger means that their political identity as the Shiv Sena is lost then.
Well, then in that case, if the 10th schedule says that I recognize only this path of exit from this room, you can't say I'll make a new tunnel to get out.
But Dr. Singh,
He can't make
part
a
of your argument is a problematic argument.
Problematic.
I'll tell you why. Because your argument postulates that if you have a dissension, then the only way you can express the dissension is to leave the party and merge somewhere else. They say, sorry, we don't want to leave. I mean, ideologically, I am a Shiv Sena man. I don't want to leave, he says. He says, I don't want to leave the party.
So as per
kindly see the consequences.
even if somebody applies to the election commission at the initial stage instead of in the legislative assembly,
correct,
and says that we now want the political party to
that we are the political party, recognize us.
So even that, according to your argument, is impermissible then?
No, because
that's outside the
so long as
5 instances that you have given.
No. One of my 5 is EC.
He's not resigned.
I beg your pardon. No. One is resignation, one is split, which is gone now, one is merger. The 4th is EC.
He's saying that
4th is EC. Now, whereas if I apply to EC without violating a whip and get a decision, if I apply to EC without voluntarily resigning, it's perfectly permissible. I can't be saying I'll topple first and then I'll apply to EC.
So remain a member, be a part of it, and
contemporaneously vindicate your principle. Absolutely. But I just see the reverse of it. But just consider how it will apply. You first topple the government, then you go to the EC. And why did you write the 10th schedule?
That we understand.
No, and also, apropos my Lord Chief Justice's query, are you harmonizing or not? There is one more thing. The fact that you don't choose consciously not to exercise an option does not mean you can wish away the option. The option is a constitutional option. It's a constitutional option. It's as equal to split as it was earlier. You don't exercise it, it really amounts to saying this: I want to avoid the 10th schedule. So I will put blinkers and close my eyes to 4 options available. 4 constitutional options. The 5th one is deleted. And I will choose a new option, which is only the 3-step procedure. First, disable the speaker. Second, approach the governor. Third, be sworn in.
See, the negative prohibition in the 10th schedule is twofold. 1, voluntarily giving up a membership. And 2, defying a whip, 2(1)A, 2(1)B. The 10th schedule certainly does not have any provision by virtue of which there is a prescription if you do not give up the membership of the party and yet exercise the right of working your remedies within the party.
Then you cannot be held to be a defector.
Right.
And that is the whole purpose. You were elected.
That's exactly the case, no?
No, but then in that case, why did you enact the 10th schedule? Because 10th schedule is not saying that Article 19(1)A, just see 194, very interesting article. Let me put this harmonization, which is a very important principle, in another way. What is the scheme of this entire system? Well, if your Lordship were to make a standard as broad as if you have a dissent, you can violate the 10th schedule, then your Lordship will unmanageable.
But your argument, Dr. Singhvi, would be, the extreme argument on this side, which possibly you can adopt also, is that any dissension amounts to the voluntary giving up of the membership of a party.
No, I'm going to give more. I'm not extreme. The other argument is extreme. I'm going to give a harmonized answer. Immediately to that, the principle can never be dissent. I'm not happy, therefore I can go. 3 answers. 1, everybody has dissent. Which political party? There are enough inbuilt outlets within the party to express dissent. 1. That is what your Lordship will always say. 2, the dissent within the party at the appropriate fora can be followed by any of these 4. 3, you, if you are having dissensions and you are not satisfied with the party system, then you will simply express it that I am resigning or going away with 9/10 of the people. But how will you say that mere disagreement entitles me to topple? Here they have not expressed dissent. This is not a case of dissent. I have not gone out and spoken against the party. Dissent plus, this is dissent plus. Dissent plus toppling. Your Lordship remembers I started, I think there was another Brevia hearing. Your Lordship notices 191(2) and 194. Lordship may not remember that, but just kindly turn to that for a minute. 191(2) is a clear statutory, the constitutional prohibition in the 10th schedule saying you shall be disqualified. That's the 10th schedule comes from 191(2). Now, well, it's 194, which follows 2 clauses later, says, subject to the provisions of this constitution, there shall be freedom of speech in the legislature. And whereas 19(1)(a) is even more reasonable restrictions. Now, it can't be that mere saying free speech, I can violate, I'll violate, you can act within the party constitution. Whatever the party constitution allows. Some party constitutions have even appellate bodies, some have 2-level things. You can actually do all of it. Before you go by these 4 escape routes of merger, resignation, you can do all of it. But ultimately, if it doesn't work, you have to take these 4 routes. And 194(1) makes it clear, subject to the provision of this constitution and to the rules and standing orders regulating the procedure, there shall be freedom of speech in the legislature of every state. This is not an open-ended charter. And plus, kindly see the consequence.
Dr. Singhvi, according to you, when does the governor then order a trust vote?
No, the governor has no role at all in such a situation. Governor, first answer to your lordship is when the government is formed or when the government is about to be formed. That's the inception argument. The governor will never come into a 10th schedule situation. It's what is your lordship considering? An intra-party dispute. At the end of the day, what is this? Dissension. I don't like you. I think intra-party. How does it come to intra-party dispute? How does it even recognize it? There are all kinds of feuds going inside parties. How does my lord lay down in English language a judicially manageable standard to control the governor peeking into intra-party disputes for us? It will be the thin end of the wedge. This is nothing but political party A intra. The governor will deal with some constitutional issue or something relating beyond intra-party. And how will the governor deal without any specific article, mind you? In a sense, superseding and overdoing the 10th schedule, which is a constitutional article, with 191(2), which we tend to forget. 191(2) read with the 10th schedule.
Step 1 was, as we saw, the three steps that you told us. Just
Yes.
1 second, I'll just go back to it.
Correct, Police.
Notice of removal to the speaker,
Yes.
resolutions given to the governor, and the act of being sworn in as CM.
Correct.
There's one step earlier, probably one step which you can also add there, which was the governor's trust vote communication.
I'm grateful. I'm grateful.
Right. Now,
4-step
there,
procedure.
suppose, notice of removal of the speaker, we are not really called upon to adjudicate upon the validity of the...
Except in Navam Rebia. Your lordship, if your lordship chooses to refer, would have that issue. Navam Rebia,
If we choose.
in the broad, I'm saying it arises. I'm not saying your lordship may have to for this case. I'm saying that's the core issue. I'm saying it's an issue.
The governor asked for a trust vote.
Yes.
2 ways of looking at it. While the governor had material to call for a trust vote, in which case a further issue would arise as to whether he was justified in calling upon Shinde to form the government.
Pinpointing, picking out a person and saying.
Picking out a person, because
Correct.
even assuming that the governor had material to call for a trust vote, what is the basis for picking out Shinde? Second, that the governor had no material to ask for a trust vote.
Absolutely.
That there was no valid material at all
That's a
on the
core
basis of those 3 circumstances.
That's a core question. And that goes to the heart of the matter. If I may digress for 30 seconds, Mr. Tushar Mehta was right when he quoted the couplet. But perhaps he didn't realize that the second sentence applies against him. He quoted Bashir Bhadra to say, "Chup rahe to galat fehmiyon और गलत फहमियां और भी बढ़ी, उसने वो भी सुना जो मैंने कहा नहीं, उसने वो भी सुना जो मैंने कहा नहीं." The governor in his letter at 326 PDF talks of a resolution to exit the government, which doesn't exist at page 55 as the resolution is itself there. So he's hearing things jo kaha nahi.
The resolution doesn't say that we are exiting the government.
Yes. So he heard something.
We had wanted to.
Well, I found a more appropriate one for Mr. Mehta. I found a more appropriate phrase for Mr. Mehta. Not Bashir.
So the really question was whether there was a valid exercise of power by the governor to call for a trust vote. And but what happens if we come to the conclusion that there was no valid exercise of power by the governor to call a trust?
Everything false.
Everything false is very...
No, fine. I'll be dealing with Boman. That's the core question. Your lordships is saved a lot of unnecessary exercise if your lordship comes to that conclusion plus follows Bomai, which in any case is...
So then you, according to you, what? We reinstate the Uddhav Thackerey...
Straight away, let me first change my tack. So let me end this first point by saying, let me end the first point by asking myself a reverse question. What happens in my first point of affirmative and negative if your lordships were to accept their interpretation? That's a good way of answering my malicious proposition. Namely, your lordship will have nothing left in the 10th schedule. How does the lordship operate both? The 4-step or the 3-step becomes the norm. and will be followed in every case to defeat the 10th schedule.
We got it.
That's my first point.